Good day, it's nice to have you back. From the previous videos we know that through Article 2, Paragraph 3 of the UN Charter, states have an obligation to settle their disputes peacefully. However, Article 2, Paragraph 3 does not say how. It does not articulate an obligation to submit disputes to an international court. Today we will speak about different methods of dispute settlement. What other options are there besides international courts to settle international disputes and to protect global values? And what are the advantages of international courts above these other mechanisms? In general, we distinguish between diplomatic methods on the one hand and legal methods on the other. For the first type of dispute settlement, the diplomatic methods, diplomacy and negotiations are central. Whereas for the second type, the legal methods, the law plays a decisive role. Why would states in certain situations favor diplomatic dispute settlement over legal dispute settlement? Please write down your answer now and check at the end of this module whether you still agree with your own answer. Article 33 of the UN Charter lists the most important dispute settlement mechanism. It reads, "The parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace and security, shall, first of all, seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, or other peaceful means of their own choice." The most common diplomatic method of dispute settlement is negotiation. In negotiations, there's no third party involved. Negotiations are purely bilateral between two parties involved in a dispute. The most common legal method is judicial settlement by a third party, namely a court. In between, we find a range of other methods where a third independent party plays a certain role. This third party can be a person, a state, or the UN, and his or her role can be more or less decisive. So the decision of a third party can be an advice, or it can be binding upon the parties to the dispute. In framing his advice or decision, this third party can rely on law or not. These are all matters of gradation. So let's first explore the diplomatic methods of dispute settlement. Diplomatic methods that go beyond negotiations because they include an independent third party are mediation and conciliation. A mediator may intervene in a dispute by assisting in the negotiations and even proposing solutions. Examples of individuals and institutions that have often mediated in international disputes are the UN Secretary General, the International Committee of the Red Cross, or the Pope. The Pope has mainly intervened in disputes between Latin American states. A famous example is the Beagle conflict between Chile and Argentina, where Argentina, an overwhelmingly Catholic country, renounced the use of force and accepted papal mediation. So we see how effective mediation can be. Conciliation is a more institutionalized form of mediation, and often done in the form of conciliation commissions. Recommendations of conciliation commissions are not binding on the parties, which underlines the diplomatic nature of this mode of dispute settlement. We can find an example of institutionalized conciliation in the context of human rights. In many regional human rights systems in Europe, Latin America and Africa, individuals may lodge complaints against states directly to international courts or sometimes to commissions. Very often in the procedures of these courts and commissions, there is first an obligation for the court or the commission to find a friendly settlement between the individual and the state to whom the complaint has been addressed. Such a friendly settlement does not need to be based on law and can thus be seen as a conciliation exercise. In contrast to diplomatic means, legal methods are based on law. The prime examples are arbitration and judicial settlement. The difference between the two lies in the extent of control that parties to the dispute have. In both cases, the dispute is settled on the basis of law, But in case of arbitration, states can choose the arbiters, the law and the procedure, whereas in case of judicial settlement by courts, these matters are all predetermined. So as you will learn in the next module, the bench of the International Court of Justice is composed of 15 judges, and parties to a dispute cannot choose their own judges, with the exception of the judge ad hoc. More about this in the next module. In many present-day treaties, we often see a mixture of methods, a combination of diplomatic and legal means. For instance, many treaties compel states to endeavour to settle their disputes about the treaty through negotiations first, and only if this has proved impossible do these treaties indicate that a dispute should be referred to the ICJ or to arbitration. One example among many is the Convention Against Terrorist Financing. Article 24 of this convention stipulates that disputes must be solved through negotiation, and if this is not possible, then through arbitration. And if this proves also impossible, the dispute may be referred to the ICJ. Lastly, I would like to draw your attention to a distinct method that has gained importance recently and that will only continue to increase in relevance in our ever-complex world where facts are often disputed. The method that I refer to is called inquiry or fact-finding. Of course, courts establish facts as part of their case law, but inquiry can also be an independent dispute settlement mechanism. The conceptual father of the idea of inquiry was Friedrich Martens, a Russian diplomat and one of the protagonists of the Hague peace conferences that we discussed in the previous video. Martens believed that inquiry, or the impartial establishment of facts and circumstances surrounding international disputes by an independent commission, would help to cool off emotions and would help preempt an exacerbation of conflicts between states. The idea was that an independent clarification of the facts before diverging views could arise would create a mutual understanding of events and thus prevent a deadlock between the parties to the dispute concerned. Today, we see a renewed use of this method of inquiry by the UN Security Council and by the UN Human Rights Council. Did Iraq possess weapons of mass destruction in 2003? Who used chemical weapons in Syria in 2014? Commissions of inquiry are sent off by the two councils to conflict areas and sites of unrest to report on such matters, as well as the overall human rights situation. So in these situations, inquiry is not so much a mechanism anymore to settle disputes between states, but rather a means to address global threats. So now that we have an overview of diplomatic and judicial methods of dispute settlement, and that we have seen that some mechanisms, like inquiry, can transform along with a changing international order, we conclude by recalling the question that I posed to you at the beginning. Why would states opt for diplomatic rather than judicial dispute settlement? Do you still agree with the answer that you wrote down at the start? And which of the following options do you select?